4, 3, 2. All right, it is the 12th of November 2025. We are here at the DPSST in the main boardroom, and we are going to call the Corrections Policy Committee to order. Read the statement here. Corrections Policy Committee Administrative Announcement. This is a public meeting subject to public meeting law, and it will be digitally recorded. Deliberation of issues will only be conducted by the Corrections Policy Committee members unless permitted by the chair. Remember to always state your name for the record. For cases dealing with denial or revocation, only information contained in the staff report can be considered once the staff report is adopted. Assumptions, outside knowledge, or personal experiences should not be included in any discussion. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to other persons in the room or makes it impossible to continue the meeting. With that, if you want to do introductions.
When I call on you, please state your name and who you represent for the record. We'll begin with you, Chair Hunter.
You first.
Oh. Nick Hunter, Marion County Sheriff, representing the Oregon State Sheriff's Association.
Vice Chair Cameron.
Jennifer Cameron, non-management call and probation.
Member Aldridge.
Hi, Josh Aldridge, Jackson County Sheriff's Office, representing the Oregon State Jail Command Council.
Member Bowden.
Margo Bowden, non-management corrections.
Member Frosco.
Lori Frosco, Department of Corrections, absent.
And then online we have Member Frost.
Sorry, John Frost, Snake River Correctional Institution, ASME non-management.
Thank you. Member Hartford.
Mike Hartford, Oregon Association of Community Corrections Directors.
And then online again we have Member Langley.
Ted Langley, Lynn County, Oregon Jail Command Council.
Member Mays.
Mike Mays, East Oregon Correctional Institution, ASME, non-management.
Member Stephan.
Brian Stephan, Chief of Security for the Oregon Department of Corrections, sitting for the Director.
And now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Erica Riddell, Criminal Justice Support Specialist, DPSST.
Cindy Park, DPSST.
Melissa Langbacho, Case Coordinator, DPSST.
Kathleen McAlpine, DPSST.
Marie Atwood, DPSST.
Ben Hamilton, DPSST.
Jennifer Howell, DPSST.
Chris Enquist, DPSST.
Sam Tank, DPSST.
And that's it.
All right, thank you, Juan. Did everyone have a chance to take a look at the minutes? And are there any questions or concerns regarding the minutes as documented? If no questions or concerns, is there a consensus to accept those minutes as documented? Not seeing any objections, we'll accept those minutes. I did not see that there are any administrative closures on this one. So, rightfully so, we'll just skip the administrative closures. That's a whole box I get to jump out of the way. I'm just saying. All right, professional candidate standards case for review. Looks like we do have a few people that are going to appear in person. So that will take us slightly out of order. Looks like Shane Bond will still be first, and then we'll move on to Bonnie Kessel, and then unless one more person shows up, we'll follow the agenda as written.
I don't have anything for Shane Bond.
So I actually found that one this morning and did have a chance to look at it, but I literally only found it this morning.
Was it only online and not in our books?
It was online, not in the books.
Oh, okay, you know.
It was the tough part about looking at the amended agenda. You had to figure out what was amended on the agenda and what it was Shane Bond was added to the agenda.
I'm going to jump in here. This is Marie Atwood for the record. Could I just get a general idea of how many people on the committee have had a chance to review the materials for this particular case? Maybe by show of hands?
Juan, can you wait a minute?
1 second.
Wait,
Can you
hang on
for
a
a
second.
second? Show of hands, I see 1, 2. How about online, if you've had a chance to read these? Looks like a little bit of, okay.
Everybody online.
So considering we have a we have a quorum, but we also have a considerable number of people who haven't read the materials for this case. Our options could be to proceed, and those who have reviewed the materials can participate in the discussion. I don't want anyone to feel unprepared or underprepared. Or I suppose we could have kind of a consensus or a vote among the committee to postpone this case to a later date. I'm hesitant to do that because Mr. Bond is here in person. So I guess I'll leave additional discussion on that issue to the committee for now. Does anyone have any particular thoughts or feelings one way or another?
Brian said for the chair, or for the record, to the chair. I also saw it, but it was a last minute. I perused through it, I was scanning through it this morning as well, just to refresh. I don't feel strong enough to carry the conversation on this.
Okay.
Ted Langley for the record. I think holding off on allowing the entire committee to participate would be appropriate, in my opinion.
Nick Hunter, I have a question then.
Yes.
Probably for Marie. Since he drove from Union County, can we allow him to still provide his mitigation now? And then I'm good with holding this till the next time to discuss, but is there a way he can provide his mitigation now?
I actually think that's a pretty good midway solution. This is Marie Atwood again for the record. If all are in favor of that, can you show just by hands or thumbs up, receive mitigation today? We will get that transcribed and add it to the written materials and then revisit the case next time. Okay. I, in that case, will go out and relay this information to Mr. Bond so that he knows what to expect moving forward, and then we'll come back in.
It's 149 pages to review.
On his 149.
Yeah.
Yeah,
Because
it's
I haven't
actually
had
not
access to it.
complicated at all. That most of those 149 pages, and not to shade the record, but they're police reports.
Well, usually that's what they are for everybody, so more information or their training records or those kinds of things.
But I would agree, I think it's worthy of, this one's worthy of discussion, so.
Hello, everybody. My name is Shane. I have prepared.
Hang on just a sec for me, Shane.
Oh, yes, sir.
First, you can have a seat right there. buddy.
Okay.
Is there a specific that I'm missing other than that meeting?
Hang on for a second, we're gonna go a little out of order.
No worries.
You're gonna see the time.
Yeah, but there's no like, there's no actual written dialogue down here. No. Okay, all right. Good morning, Shane. So you'll have 5 minutes, once the timer starts, to provide your mitigation. No questions will be asked, no further participation after that. That 5 minutes will be your time to use as you see fit.
Sure.
You understand?
I do.
Okay.
And Chair, one comment, Cindy needs to present the case first.
Oh.
Yeah.
Sorry, Shane.
No worries.
Okay. Cindy Park for the record. We're here to review Shane Bond. A case was opened by the department after receiving an application for training, or F5, and a criminal history reporting form, or F28, in which Shane Bond disclosed previous criminal dispositions. Because Bond worked as a reserve police officer with the Umatilla County Sheriff's Office from 2016 to 2017, Bond's position requires that his pre-employment criminal dispositions be reviewed before the full committee rather than the applicant review committee. On March 2nd, 2017, Bond was arrested for the offense of driving under the influence of intoxicants in Pendleton, Oregon. He pled guilty on March 28th, 2017, and entered a diversion agreement. And ultimately, Bond failed the diversion and was convicted of the charge on March 28th, 2018. On October 3rd, 2017, Bond was arrested for the offense of DUII in Umatilla County, Oregon, and pled guilty to that charge in January of 2018. Bond was cited on 3 occasions for the offense of criminal driving while suspended, a misdemeanor, April 2017, October 2018, and May 2019, and was convicted in each case. Moral fitness violations, Bond violated criminal law and has 5 misdemeanor criminal dispositions for DUII, 2 counts, and criminal driving while suspended, 3 counts, to violate the moral fitness standard of misconduct. Additionally, Bond violated the board's moral fitness standard for misconduct when on 2 occasions he chose to drive a motor vehicle on a public roadway while under the influence of alcohol. His actions placed himself, others, and property at risk of harm. Chair.
Thank you, Melissa. Okay, Mr. Bond, you will have 5 minutes. Who's got the?
Okay, you got it.
Okay, Cindy, you ready?
Okay. Thank you for the opportunity to speak in person today. I want to begin by acknowledging that I take full responsibility for my actions. I know that those actions did not align with the standards of someone who is sworn to serve and protect. I do not want to make excuses. I want to take ownership, show the progress I've made, and to express my unwavering commitment to both personal recovery and the values of this profession. Law enforcement is not just a job to me. It's my purpose and my way to give back to my community. I took an oath to uphold the laws and protect others, but along the way I lost my balance. The stress and trauma of losing someone very close to me affected me in a way I did not fully understand at the time. I let that build up instead of asking for help, and that choice to carry it alone led me down a path that resulted in mistakes that I regret deeply. Since that time, I've made recovery not just a goal, but a way of life. I sought out professional help, counseling, and completed my recovery program. I've surrounded myself with mentors who hold me to the highest standards, and now I have a loving wife and beautiful family who also give me purpose. This experience has humbled me and reminded me what it means to truly serve. Through recovery, I've realized that strength isn't about being invincible. It's about being honest. Honest about when you need help, honest about mistakes, and honest about commitment to change. Those lessons have made me a stronger person, and I think a better officer. I want to make it clear that my commitment to law enforcement has never wavered. I've dedicated years to this career, and that sense of duty remains deeply rooted in who I am. I know that trust is earned, not just given. What I can promise is that I will continue to live the principles of accountability, service, and recovery every day. I want to use my experience, including my mistakes, to help others in this profession who may be struggling. If I can turn my hardship into a lesson that prevents another officer or even somebody I may encounter in the jail from going down that road, then something positive can come from all of this. I recognize that wearing the badge is a privilege that I do not take for granted. My goal is to serve my community with a renewed purpose as someone who understands the weight of that responsibility more deeply than ever before. In closing, I want to thank you for hearing me out today. I stand before you not as the person who made those mistakes, but as someone who confronted them, learned from them, and has grown through them. I believe in redemption, in recovery, and the power of service. If given the opportunity, I intend on proving that the past does not define the person standing before you today. Thank you so much.
Thank you for your testimony. I heard this at Marshall. I don't know where you want to go from here.
Chair, for the record, Catherine Calpine, Mr. Bond, can you just, inform the group, when are you expected to start the academy?
I believe that would be January. I don't know the exact date.
Okay, but January,
Yes, ma'am.
okay. Just for the, committee's consideration, if we need to put it off, which is fine, it'll be in the next meeting, which then the agency, our department has to decide whether or not we hold off on letting him start in January, or, yeah, and know this is holding over, and should you, the committee recommend taking action, then we've gotta wait for the board, it could be well into the academy, so, and we've experienced where we've had to remove, and that's not a good feeling for either side either. So just, that's just one consideration, when we're deciding whether or not you can, the committee feels like they can move on today or not.
Yeah, kind of for the record, Deputy Director, I want to ask one more question. I'm just not sure if that question, for me to ask that, is appropriate to ask that in front of Mr. Bond sitting here right now.
Well, Chair, I think, again, if you want to say for the record, I believe there's a significant amount of committee members who did not get the link or did not have a chance to see it. So I don't think that anybody's able to make a decision today. Is that correct?
Yeah, I would agree with that.
Yeah.
I think my question was going to be over eligibility period, because if you look at the eligibility period, I think that does create an interesting factor in this one. And whether that influences, it's not really our decision anyway, it's the academy's decision. So I guess that doesn't necessarily matter. I think the bottom line is not enough people have had the chance to review and prepare. So it would be my recommendation that we move this to the next meeting.
Concur. And again, Captain Calpin, for the record, I think, Mr. Bond, you were advised kind of in the hallway of the circumstances. However, we want to recognize that you drove a significant way and wanted to give you the opportunity in this space to be able to give your mitigation. Carrying it over, of course, you could listen in. You don't have to drive all the way here. Your mitigation will be transcribed. Everybody here got a chance to hear it. Of course, we'll always give you space if you want to come back again and give another 5 minutes, but Ms. Park will keep you informed on to the status of that, and we'll also communicate with you on your January start date.
Okay.
Yeah.
Work for you, Chair?
Yeah, I concur.
So for now, Mr. Mountain will go out there.
Thank you all again.
Thank you.
They don't want like when, right, we're putting on the top that it's in the, so maybe that's something that we should make. Right, yeah. Yes, and I remember seeing something like that, which I know we get it, but sometimes we're balanced. Just, that was easy to reference. Yeah.
Gutierrez isn't in the lobby and is not online. So
Okay.
Thank you, Lisa.
Good morning, Ms. Kessel.
Good morning.
In a minute here, we'll have the case read, and then once the case is read, you'll have 5 minutes to provide your testimony. Won't involve any questions or follow-up or anything else, but that 5 minutes will be yours to use as you choose. Understand?
Mhm.
Okay. We will have the case introduced by Melissa.
Melissa Lane Blatcher for the record, morning, Chair and Corrections Policy Committee members. The department opened a professional standards case to review Bonnie Kessel's separation from the Umatilla County Community Corrections, which was reported to occur as part of a settlement agreement. Her separation followed an internal investigation with sustained findings that she was untruthful when questioned about the release of information and failed to meet performance standards. Kessel's untruthfulness was related to a disclosure of information to an employee of another agency that an offender was the subject of an active criminal investigation. When Kessel was asked if she disclosed the information, she denied that she talked about the offender's investigation. The department reviewed the information and previously presented the case as an administrative closure to the committee in May of 2025 and has returned the case at the committee's request. The department again did not find sufficient information to make findings in this case, and Chair Ms. Kessel is here to provide a verbal statement to the committee for consideration. When you're ready.
Thank you, Melissa. Okay, Ms. Kessel, you will have 5 minutes. There'll be a timer that sits right here that'll show you. It's right, actually. We'll show you from right there. And the floor is yours.
Okay, so my name is Bonnie Kessel. I work for Umatilla County Community Corrections for 16 and a half years. Part of the latter part of my years, I was a supervisor. I didn't do the best at that position, and as a result, I stepped down almost a year prior to this situation that occurred. With the person that we're speaking of, I did a mini intake on him, I guess is what you would call it, the day that they had returned from residential treatment. And the treatment providers, our local treatment providers, had switched names, actually agencies. So I mean, there was some contention in the office, and I wanted to make sure I did a good job. So I did all the information, all the paperwork, and I sent the person down the street to the outpatient. And I can remember speaking with the counselor on the phone, walking down the hallway, and to the best of my knowledge, I said that he was being charged. At the time later, when this occurred, when this came up and I was asked about it, and this was wrong of me, I was in a hurry, we were going to have lunch, everybody was at the restaurant, it was hasty, and I didn't recall at all the conversation. To this day, I don't remember the date that I actually seen the gentleman in the office. I don't know what date that was because I didn't ever return to the office to look at any documentation. But I know the day that I was asked about it by my supervisor, I was in a hurry, and yeah, I was just in a hurry. When I left the office that day after I told her I made 2 phone calls. One was to the lady that actually said that I had told her, the counselor, and then one was to my union president, because I just called to say, you know, is this something that I need to worry about? But in my haste, I didn't even pay attention when I was being asked, and that's the truth. It was very quick, and as a result, here I sat. There was an investigation. I didn't remember, when I got to the restaurant that day, I was pretty upset, and we were having lunch as an office. And one of the office people there was she was a PO tech, and she's the one that said, I was the one that had said to her mother, who was the counselor, that I had talked about it, and so therefore that's how the information was passed to the counselor. I didn't remember at the time. The conversation I had with the counselor was very brief and walking down the hallway, because it's like, is he there? Yeah, I believe he's in the lobby. And I really was trying to do a thorough job because of the contention in the office, because I wanted to make sure that the counselor had gotten the information, because the guy had just been released from residential treatment. But that is what happened. And I had two aha moments. When I was doing the investigation, my assistant director asked me what my aha moment was. The first aha moment was when Cassie, the PO tech, told me, "You're the one that said this to my mother." And then the second aha moment I had was when it's like, usually as a probation officer, you don't get asked questions. You don't ask questions of other people unless you know the answer already. So looking back, I realized, Don already had the answer, my supervisor. And those are my two aha moments. I've done some training when it comes to HIPAA. I'm in a position now that I don't have to sign releases of information, but I was always pretty good about having those papers signed. I even did so that day with that gentleman. But I have done some training in regards to confidentiality. I've also done some personal counseling. It was a pretty big impact. I mean, I was with the county for 22 years, just about 16 and a half of that was with probation. And it was something that I really enjoyed. It was something, I was really pretty good at it.
Thank you for your testimony.
Okay.
Okay. So the committee will now look at the record as presented by the staff report, and is there a consensus to adopt the staff report as written? Chair Hunter, for the record. I'd like to make an amendment.
I believe she desires to leave and not listen to the deliberation.
Sorry,
No, it's okay.
It's okay, we're working through this because it's my first time sitting in this seat, so it's quite possible that I was supposed to tell you that instead of just making
Well, I
you sit
knew it,
there.
I just didn't know my cue. Thank you.
Yeah, you certainly can stay if you would like to.
I'm pretty sure.
Okay, thank you.
Thank you.
Thank you.
Didn't tell me this was such a challenge the first time I had to work through this.
Hey,
All right.
you will do just fine.
I got you.
I believe in you.
So back to my, again, Nick Hunter for the record. I would like to propose an amendment to the staff report. The staff report has come to us once, come to us again. There is still no finding for dishonesty. I think that there is sufficient information in the record to support dishonesty, whether the deliberations find that to be intentional or unintentional, I believe should be sorted out during the deliberations with this committee. But I do believe that the record itself reflects that dishonesty in some way, shape, or form occurred during this interaction with Ms. Kessel. So I would propose to accept the staff report with the amendment of dishonesty being included.
I'll jump in here. This is Marie Atwood for the record. I just want to make sure the committee members, kind of just for your general awareness, know the administrative rule definition for dishonesty for cases like this can include both intentional dishonesty or reckless disregard for the truth. So.
Mike Hartford. for
Josh
the
Aldrich for the record. I would second Sheriff Hunter's motion in large part because I do think that it's important to have some open deliberation around the interpretation of the dishonesty in this case.
Okay, Nick Hunter for the record. So I guess to be clear then, I was making a motion, yes, that we amend the staff report to include dishonesty, otherwise accepting as written. And sounds like Josh is going to, Lieutenant Aldrich is going to second that.
Yes, I would second that.
All right. We are voting on a motion to amend the staff report to include dishonesty. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Fasco?
Aye.
Committee Member Frost,
Aye.
Committee Member Hartburn,
Aye.
Committee Member Langley,
Aye.
Committee Member Mace,
Aye.
and Committee Member Stefan.
Aye.
Motion passed.
Okay.
I wanted to make Jennifer Cameron for the record. I don't know if we can just talk about it, but I'm wondering if also misconduct might be included in this, and I don't know about the definition specifically, but what bothers me about this case is that there was information that was shared that could potentially interfere with an active investigation, which I think harms the agency potentially that was doing the investigation, but also the credibility and the working between the agencies. And the misconduct definition is conduct that violates criminal laws or conduct that threatens or harms persons, property, or the efficient operations of any agency or discriminatory conduct. And I don't know if it would fall into that efficient operations of any agency or not. So I'm throwing that out there just to kind of get a feel for what people think.
So Nick Hunter, for the record, I'm gonna ask more questions. So we made a motion, we made an amendment, that was voted upon, accepted, and now the vice chair is making another recommendation. Can we have a second motion to amend the amendment and include misconduct?
I don't see why not.
Yes.
Jennifer Howell, for the record, I would say yes, and I would say in essence, you've adopted the record for what the basis of your discussion, and you've already kind of advanced into the concept of amending the moral fitness violations, and I don't know if you're officially amending those yet, or if you're just adding these things to the record so that they can be discussion for whether or not to affirm, modify, or negate the moral fitness, which is a later step. So if there's clarity for the process going forward as to whether you all are naming these as moral fitness violations now, or whether you're just naming them for consideration.
Nick Hunter, for the record, not to speak for Jennifer, but I think that they have to be identified on the front end of this in that staff report if we are going to discuss them further. Otherwise, we're discussing something not identified.
Okay, I understand that perspective, and so it just may feel a little bit repetitive later on if you all choose to, and it's fine that it's repetitive because it's keeping the record clear.
Okay, so Nick Hunter, for the record, I will entertain a motion.
Well, Jennifer Cameron, if possible, I'd like to make a motion to amend the staff report to include a moral fitness violation of misconduct, which includes conduct that can affect the efficient operations of any agency.
Ed Langley, for the record, I would second that.
So we have a motion and a second.
All right, we are voting on a motion to amend the staff report to include misconduct. Chair Hunter?
I'm sorry. So we're amending the amended staff report, just for clarity's purposes.
Yes.
So the amended staff report has dishonesty added, and this amendment of the amendment is adding misconduct.
Yes.
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartburn?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Stefan.
Aye.
Motion passed.
Thank you, Cindy. Okay, we'll open the case up for discussion. Remember to state your name and identifying any aggravating or mitigating factors.
Jennifer Cameron, for the record. aggravating factors include that, information was relayed to, this wasn't necessarily about HIPAA, this was about an active criminal investigation that was, being active and it's not public information, and that information was disclosed to a person who has no need to know that, which risked the offender finding out and, ultimately sabotaging an ongoing criminal investigation and other things, which I think is misconduct and not appropriate.
Brian Steffen, for the record, she, when she gave her testimony, I really didn't feel like anything was mitigated, just confirmed that she was talking without thinking.
Mike Hartford, for the record, I want to note her tenure in public safety, 16 and a third years, it looks like, if this record is correct. By that time you would, and being a supervisor at one point, you would understand confidentiality as well as what lying does to our profession. So with her tenure, she should have known better. I remember, not to opine about other cases where somebody in FTAP had lied, and we discussed giving that person another opportunity because of their length of service. And so I think this is similar on the other side of that, where somebody has been in the business for long enough to know better.
Nick Hunter, for the record, aggravating factor. During the initial questioning of Ms. Kessel, she denied this knowledge 3 times. I was not clear from her mitigation that she addressed that. She didn't appear to take any accountability for the clear harm that had got caused in this situation. She seemed more to continue to justify it. And on the initial, where she denied 3 times, her third denial also involved a very claused answer where she said, "That's awful. Who would do that?" That's awful. Who would do that is shows intentionality to her response, not as she has proposed it as hasty or nervous. It's actually intentional in how she's responding to that. I'll stop there. Actually, no, I'm going to go on. Nick Hunter, for the record, aggravating factor. There was another question that caused me concern that was asked of Ms. Kessel, and it involved, had she previously shared any confidential information from law enforcement? Her response was, "Not that I can recall." And I believe these were similar to her other responses of not wanting to take accountability for things that she had said in previous situations, as this was all kind of confronted upon her in a single time.
Mara Bowden, for the record. One of the aggravating factors I had was a conversation when she was having with this Jim Myers, and she was asked about, basically she said that she didn't know if it was, or she got her mom and her confused that day when she was talking to her. I would think that you would know who you were talking to. And it just seems like she keeps falling back to like, I don't know, I just don't know if I was talking to her or her mom, or, and then it seems very confusing to me that she doesn't know who she was speaking with, and the actual correct person. So there's a lot of I don't know, and I take the no accountability thing for me is a hard thing, so.
Ted Langley, for the record. I also found it aggravating that for somebody with as much time in service as she has. It's no secret to anybody in law enforcement that dishonesty of any kind is basically a death sentence to your career. And yet she chose not just once, but multiple times to be dishonest when she was questioned.
Nick Hunter, for the record, aggravating factor, she shared confidential information. I think that needs to be brought into the record as well. Nick Hunter, aggravating factor. Multiple times she was asked for information throughout this entire investigation where she provided very specific details about everything else that happened during that day. The only thing that she seemed to be unable to provide was the information regarding what she had told the provider. Every other detail of the day seems to be well addressed, right down to people at a haircut, leaving that haircut, coming to the office. All of those things were provided except for what exactly she told that provider. Any other aggravating or mitigating factors? Melissa, can you read back what we have?
Yes, thank you so
Thank you.
very much for going slow so I could get all of that. I didn't hear any mitigating information, and for aggravating, have noted that the information she relayed related to an active investigation and shared with an offender sabotaged a criminal investigation. The mitigation she provided today did not mitigate her actions. With the length of her employment, she should have known that she needed to keep information confidential. She denied 3 times that her actions, she denied her actions 3 times and did not take accountability, which she did not address in her verbal statement. Her statement regarding who would do that to her supervisor shows the intentionality of her actions, and her statement, not that I recall, was also an indicator of this. Statements that were given in the investigation were related to saying, I don't know, and ask questions when she should have known the information, show that she lacks accountability for her conduct. Her dishonesty was multiple times when she was questioned, which she should have known could have a serious impact on her career. She shared confidential information, and at other points in the interview that she gave with her employer, she gave very detailed recollections, and then specifically only did not recall the information when she was asked about the offender. Sheriff Hunter.
Thank you, Melissa. Okay, is there a consensus of the identified factors as have been discussed and Melissa has shared? Okay, with the consensus there, we will now move on to the moral fitness violation. The 3 options that are in front of us are to affirm, which is accepting as it is, modify, meaning making changes, or negating, remove all. And I'll entertain a motion around the moral fitness violations.
Ryan Seven, for the record, I'll move to accept the amended allegation.
We have a motion to accept the staff report with the amended violations.
Jennifer Cameron, I'll second the motion.
All right, we are voting on a motion to affirm the amended moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pascal?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
All right. So that moves us on to discussion of any period or length of ineligible. No.
Take action first.
Okay. So the next question that exists is whether, as a committee, we want to take action on this case. I'll entertain a motion.
Brian Steffen, for the record, I move that we take action on this case, as we've accepted.
Margaret Bode for the record, a second.
All right, we are voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pascal?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
And we'll now move on to discussing, if any, ineligibility period. Because this case involves dishonesty, the ineligibility period options would be 3 years to lifetime. I'll entertain a motion, and please state your reasoning for making that motion in the motion.
Brian Steffen, for the record, I'll move lifetime because of the lack of accountability and almost feels like intentional clarity while she spoke.
Mike Hartford, for the record, I'd second for the reasons Member Steffen stated.
I have a motion and a second.
We are voting on a motion for a lifetime ineligibility period. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pascal?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
Okay. Still
Does
up.
it look like Gutierrez is here, so we can go in order, Chair?
Okay, so if there's no Gutierrez, then we will go back to John Deerdorf.
Chair Hunter, Margaret Bode for the record, I'd just like to state that I actually went to the academy with Deerdorf and have been a personal friend of John Deerdorf as well.
Okay, thank you.
We haven't been in contact for about 5 years, but for quite a long time we was.
Okay, so we will start with Melissa again.
Thank you. Melissa Langbasha, for the record. The department opened a professional standards case to review John Deerdorf's arrest on March 10th, 2025 for assault in the 4th degree constituting domestic violence. The charges stem from an incident in which Deerdorf's adult daughter called 911 after she was punched in the head by Deerdorf. Deerdorf ultimately pled guilty to the charge and was given a deferred sentence. And in reviewing of the information, the department found that Deardorff, although not convicted, violated criminal law and obtained a criminal disposition for assault in the 4th degree when he entered a plea of guilty to the charge. And then separately, Deardorff also harmed another person when he hit his daughter. And the department is seeking a disposition in the case from the committee.
Thank you, Melissa. Okay. Looking for consensus to adopt the record as prepared. Seeing no objections, we'll adopt the record. So at this point, we will move on to a discussion of aggravating or mitigating factors. Please remember to state your name and identifying whether you are speaking of aggravating or mitigating for the record.
Brian Sutton for the record. Mitigating was the 19 years as a correctional officer and 6 years military service, but aggravating being that he was terminated from service in 2021. Aggravating that he didn't report criminal charges to DPSST. Aggravating that according to his daughter in the report, this wasn't the first time. This is just the first time it was went to criminal. And aggravating that although he did admit the assault, he minimized it and tried to justify it by calling her a groupie.
Kind of aggravating, I would word that just a little bit differently, that he was victim blaming in his statement to law enforcement when law enforcement arrived. Yes, it was, he took accountability, but his accountability was that he, I believe his word was, cracked her, and then blamed her for causing him to do that, and said that the victim would boo-hoo and use other language to say all the right things to law enforcement.
Jennifer Cameron for the record. I find an aggravating factor. This is obviously a domestic violence situation. What I read in the report is more that he, it seems that there's a behavior that when he doesn't get his way, he uses threats and intimidation to gain control over people, which is typical behavior for domestic violence. So the intimidation that he attempted to use, I guess, to get what he wanted.
Mike Hartford for the record, also aggravating that not only did he take accountability for the assault, but he believes that's an appropriate way to deal with problems by saying he's not going to be disrespected like that in his own house. Like violence is the answer for being disrespected, or if somebody gets up in his face, that the common or the law enforcement folks he was talking to believe that that's an appropriate response for this type of behavior, where to be violent and hurt others.
Josh Aldridge for the record. Aggravating circumstances. The plea deal included both probationary and a no weapons clause as part of the ultimate disposition of the case.
Any other aggravating or mitigating factors? Melissa, if you could read those back, please.
For mitigating, I have noted that he has 19 years of service as a corrections officer and 6 years in the military. And then for aggravating, he was discharged in 2021 and did not report his arrest to DPSST. His daughter reported previous incidents, and he minimized his conduct to law enforcement. Also, as aggravating, he victim blamed his daughter for causing him to hit her. He used threats and intimidation to get others to do what he wanted, which was typical and as an indicator of domestic violence. He took accountability for his actions, but then justified them by stating that violence was an appropriate action, and the plea deal restricts his access to weapons. Mr. Chair.
Thank you, Melissa. Is there a consensus on the what are aggravating factors? There were no mitigating factors, or yes, there was one mitigating factor that was presented. Okay, we'll open the discussion towards a moral fitness violation. The options are to affirm, modify, or negate as presented, and I'll ask for a motion. And I should say, please state for the record why you are choosing to or asking to affirm, modify, or negate. For the record, I'll make a motion to affirm from the record as stated based on the factors, the aggravating factors that were listed out in the discussion.
Jennifer Cameron, I'll second.
So the motion and a second.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Did you just want to vote?
I'll still vote.
Okay.
Yeah.
Committee Member Bowden?
Aye.
Committee Member Pasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
Okay, with an accepting of the staff report as presented, we'll move on to potential ineligibility or time periods of ineligibility. This one does not. The next question is, I will take a motion either for the committee to take action or not take action on this, and please state your name and the reasons why.
Brian Steffen, for the record, I move that the committee take action, or we recommend that the committee take action for the aforementioned reasons.
Nick, I'll second that.
We are voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Pasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
All right. Now, based on the motion to take action, we can move on to a motion for periods of ineligibility. Since this one involves misconduct, the available ineligibility periods would be 3 to 10 years.
Brian Steffen, for the record, based on the criminal disposition for assault of 4th degree and constituting domestic violence, I recommend 10 years.
Nick Hunter for the record, I'll second.
We are voting on a motion for a 10-year ineligibility period. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Stebbins?
Aye.
Motion passed.
Next case will be Emily Fisk. In this case, it's presented by Melissa.
Thank you. Melissa Lane Bach for the record. The department opened a professional standards case to review Emily Fisk's resignation from the Department of Corrections. Her resignation followed an internal investigation into her relationship with an adult in custody after 2 letters were posted by a third party to social media that were between Fisk and an adult in custody. Those letters contained sexually explicit content and a request for Fisk to set up a P.O. box. During DOC's investigation, Fisk was also found to be untruthful. In review of the information provided to DPSST, the department found dishonesty, that Fisk authored a misleading memo that implied an adult in custody had only written her 1 letter, and that the AIC gave her the letter while she was on trial service when neither of those things were true. She was also untruthful during the Department of Corrections' internal investigation on multiple occasions. She told investigators that she did not receive additional letters than those posted online when she and the AIC exchanged multiple letters. Fisk told investigators that she only wrote 1 letter to the adult in custody and later admitted that she wrote him 4 letters. Fisk denied telling an adult in custody that she was all his when in fact she wrote that in a letter to the AIC. Fisk stated in the letters from the AIC were written while she was on trial service. However, the letters were written after her trial service had ended. The department also found misuse of authority. Fisk intentionally used her position as a corrections officer to develop an inappropriate relationship with an AIC to obtain a benefit or to harm another. And for misconduct, the department found that Fisk harmed DOC's credibility and an AIC when she wrote sexually explicit letters to an adult in custody. Fisk harmed the efficient operations of the Department of Corrections when her conduct caused the DOC to conduct an investigation to ensure the safety and security of the adults in custody. Fisk threatened the efficient operations of the Department of Corrections by attempting to set up a P.O. box for an adult in custody who requested that she provide him with contraband by violating the Federal Prison Rape Elimination Act and DOC policy. And also she threatened, apologies. Sentence cut off there. Threatened DOC's compliance with the federal PREA law, which can impact access to federal funding. Mr. Chair.
Thank you, Melissa. All right. Ask for consensus to adopt the record as shared by Melissa. Okay. And that will move us on to open up the discussion for mitigating and aggravating factors. Please remember to state your name and identify whether you are presenting an aggravating or a mitigating factor.
Margaret Bowden for the record. Aggravating factors, dishonesty, not just in verbal, but also in written communication with the Department of Corrections. Aggravating having a relationship with the AIC. Keep going.
somebody else take some.
Jennifer Cameron for the record, aggravating factors, and I'll add a little here. Obviously, lying didn't set boundaries. Her actions certainly jeopardized the safety of other inmates and staff, which is obviously an issue. I found too that in her letter, mitigating letter, I don't believe that she apologized on her own. It felt like it was more coerced because she said she did it because she was asked to do it by her union rep. You know, and another thing, in this profession, it is our job to make sure we don't allow ourselves to be manipulated, and she put herself into a situation where she was potentially manipulated by an offender when she's the person who's supposed to be in charge. So.
Josh Aldridge for the record, I'll add 2 aggravating circumstances. I don't believe I saw an instance where Ms. Fisk admitted to anything that wasn't already proven to her. I'm not sure that she divulged anything truthful during the course of the investigation. So that's one. The second one I'd like to add is that record in the file shows that Ms. Fisk had went through PREA training only about 3 months prior to these incidents. So very recent and relative training that should have helped her to avoid this decision.
Mike Harper for the record, I'll agree. Her dishonesty was so many times, and every time she lied and she was called on the lie, she continued to lie. So she's incapable of telling the truth. And the second aggravating factor is that even though the AIC was participating, he's in custody and he cannot consent to a relationship like this.
Josh Holder for the record, I'll add one more aggravating circumstance. While there's not support to prove that any steps or that any actual contraband was introduced as a part of this incident, it's clear that Ms. Fisk took steps to initiate contact with a third party, which fell right in line with some of the things in the letter about making a plan to supply that contraband. So I believe based on the investigation, the only reason that was stopped is because it appears the third party did not respond and participate in that plan.
Kind of for the record, just to add on to what Josh just said, the third party thought he was being scammed and chose not to participate in that. The kind of aggravating factor for the record, it appeared she was actually trying to manipulate and mitigate her own lies along the way as she was trying to make this an incident that occurred while she was on trial services, as opposed to once she had completed trial services. So she was kind of caught in her own lies, but trying to mitigate her own lies, which shows some intentionality that she knew that there were potential consequences coming as a result of these lies. Any other aggravating or mitigating factors? So when you're ready, if you want to read those back.
Yes, Melissa Lane Boucher for the record. I didn't hear any mitigating factors identified. For aggravating, Fisk was dishonest verbally and in writing, and she was having a relationship with an adult in custody. She failed to set appropriate boundaries. Her actions jeopardized both the AIC and staff in the Department of Corrections. The letter she wrote for mitigation in her separation indicates that she was told to write a letter instead of taking accountability for her own actions. specifically. She allowed herself to be manipulated by an adult in custody instead of being aware of those situations. She did not admit to anything that was not already proven in the investigation. She seemed to be incapable of telling the truth. The adult in custody was not able to consent to their relationship. There was no evidence of contraband being supplied, but she took actions and steps to contact a third party as part of the plan for supplying contraband. A third party chose not to participate in the contraband plan, which ultimately stopped the supply. Manipulating and mitigating her actions, she manipulated and mitigated her actions to say that it occurred while she was on trial service, which demonstrated that she knew the consequences of the lies that she had told. Mr. Chair.
Thank you, Melissa. Okay, I'll entertain a motion at this point about the acceptance of the moral fitness violations as stated to affirm, modify, or negate, and please provide your reason why.
Chair Brian Seven, for the record, before we do that, I was trying to find it, and so I'm asking for help if somebody else saw this. Did she accept a friend request from him after she had already done
That was the last part of it.
on social media?
Yeah, DOC also investigated his friending on Facebook, a justice-involved individual who was on community supervision without disclosing that
I
relationship.
believe that should be added as an aggravating factor as well.
Okay, so one additional, Nick, for the record, one additional aggravating factor, unless I don't believe you need to read that back because that was just talked about.
Yeah.
And so with the additional aggravating factor added, it's now on the table for a motion to affirm, modify, or negate the moral fitness violations as identified.
Brian Seven, for the record, I move to affirm the moral fitness violations as identified.
Margo voted for the record. I second.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Seven.
Aye.
Motion passed.
Thank you. Now, to stay in the correct order, I'll entertain a motion whether the committee wants to take action or not on this case. Please remember to state your name for the record and your reasoning for taking or not taking any action.
Jennifer Cameron, for the record, I recommend that we take action for all the aggravating factors, which include violations of dishonesty, misuse of authority, and misconduct.
Brian Seven, for the record, I second.
Right, we are voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Seven.
Aye.
Motion passed.
Thank you. With the motion to take action, we'll move on to the potential periods of ineligibility phase. Because this one does include the finding of dishonesty, that ineligibility phase or period of time could be 3 years to a lifetime, and I will entertain a motion.
Jennifer Cameron, I recommend that we lifetime ineligibility.
Margo voted for the record. I second. For all the listed reasons.
We are voting on a motion for a lifetime ineligibility period. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Aldrich,
Aye.
Committee Member Bowden,
Aye.
Committee Member Fresco,
Aye.
Committee Member Frost,
Aye.
Committee Member Hartford,
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
and Committee Member Steffen.
Aye.
Motion passed.
Do that. Okay. Kind of for the record, we will take a 5-minute break and then come back. but instead we'll come back on the record at 11:22. Next case is going to be Jesus Gutierrez. Melissa.
Thank you, Mr. Chair. Melissa Lane Botcher for the record. The department opened a professional standards case to review a criminal charge Jesus Gutierrez Sr. Obtained after applying for basic correction certification. Gutierrez was charged with animal abandonment after a Facebook post he made was sent to the Baker County Sheriff's Office. In the post, Gutierrez stated that he let his horse loose in the wilderness. Gutierrez ultimately pled guilty to animal abandonment, which is a misdemeanor charge. In review of the information, the department found that Gutierrez violated criminal law, and his guilty plea to animal abandonment is considered a criminal disposition. Gutierrez's failure to provide continued care and abandonment of his horse threatened or harmed the animal. Mr. Gutierrez submitted written mitigation for the committee's consideration. Mr. Chair.
Thank you, Melissa. Okay. With the record, I'll ask for consensus that we will adopt the record as prepared by staff. Looks like there is consensus and no objection, so we will move on to open up the case for discussion, providing mitigating and or aggravating factors. Please state your name for the record and whether you are providing an aggravating or mitigating factor. Nick Hunter, aggravating factor, Mr. Gutierrez pled guilty, yet continues to state differently that he did not abandon his horse, but he in fact was prepared to and did plead guilty to that. Second aggravating factor is the witness statement provided. The witness statement provided of Mr. Gutierrez leading his horse out into the woods where he actually talked to this witness. And then shortly after, the witness reports that he left in his vehicle with the trailer, and this is when the horse was found, would completely negate the story that he provided to the Baker County Sheriff's Office and the story that he provided to the Caldwell, Idaho.
Police department?
Yeah, it's the police department, but it's the animal investigations part of it.
Brian Seven for the record with a question. We accepted the record already. In the portion for dishonesty, it said did not find substantial evidence, though there was some evidence in the records. Does that mean it's one of the things that's considered or not considered if they did not find?
Melissa Lane Botcher for the record. We didn't find sufficient information, but it is something that the committee can still find and make as they can affirm, modify the report to include additional findings.
Nick Hunter, for the record, this was an offline discussion that we were just having based on the first case that we discussed of the day. And we will get to that portion of basically accepting, modifying, or negating the moral fitness violations on the record. And at that point, we can make that recommendation through a motion to change that if we see fit following this discussion.
Brian Seven for the record. I'm aggravating, and I'm sorry if I'm saying the same thing that he just said, but the untruthfulness regarding what he had written in social media and then what he said to the police investigator or the investigator. Mitigating when he found out that there was a charge, he turned himself in to the county and to HR the same day that he found out. Mitigating human resources. He was new and human resources didn't explain to him that he needed to, according to the record, to report to DPSST what had happened. mitigating, he had the horse for a very long time, chose to set him free according to the record, rather than, because he could no longer take care of him, rather than euthanize him. And mitigating, the case was dismissed after meeting the terms of deferred judgment. The courts treated this as a learning event, agreeing not to want to affect his livelihood.
So Jennifer Cameron, for the record, I find an aggravating factor, in here, it does say that he failed to report, this to DPSST, but if you look at the documents, there is actually a criminal history recording, and I realize this was signed before, but he signed it. You should be aware that he reports that information. There were other, arrests and citations, that he did report back in April of 2022, so.
Nick Hunter, aggravating factor, although not pursued by law enforcement, you do have potential destruction of evidence. He was initially confronted about a Facebook post, and that Facebook post, there's no question that it existed, but that Facebook post was immediately removed by somebody. And then the basis for his continued lies were the now non-existence of that Facebook post any longer. So I think the aggravating factor was there could have been an additional charge under criminal misconduct, under destruction of evidence, which would have fallen under misconduct. Any other mitigating and or aggravating factors?
Mike Mays, for the record. In the report, it shows on October 20th, he told the officer that he was alone at the campground, but then later stated that he was with his girlfriend.
Nick Hunter, for the record. Mike, is your intention, can you clarify, is that an aggravating factor for dishonesty?
Yes, aggravated for dishonesty.
Hearing no other aggravating or mitigating circumstances, Melissa, if you could read those back when your pen gets caught up.
For mitigating, I have noted that he turned himself in to law enforcement, and the HR, Human Resources at the Department of Corrections did not explain to him that he needed to report the charge to DPSST. He had his horse for a very long time. The court dismissed his case after he completed the terms of his diversion and treated it as a learning experience. And then for aggravating, I have that Mr. Gutierrez pled guilty and continued to state that he did not abandon his horse. Witnesses saw him with a horse and his departure from the campground, which conflicts with the statements that he gave about his actions. He was untruthful related to what he posted online and said to the investigators. He filled out an application in 2022 and should have known that he needed to report the charge to DPSST. He destroyed evidence in the case by deleting the Facebook post, which is also an allegation of misconduct. He changed his story to say at one point that he was alone and another time that he was with his girlfriend, which was an aggravating factor for dishonesty, Mr. Chair.
Thank you, Melissa. And making up the record, I'll add one more on the aggravating factor side. When Baker County Sheriff's Office reached out to him It was 21 some odd days later before they were able to actually get into contact with them, indicating that he did not return the phone calls from Baker County Sheriff's Office, knowing what they wanted to talk about since he had already talked to Idaho. Melissa, you do not need to read that one back. With no other mitigating or aggravating factors, I will open this up for a motion to either affirm the record, modify the record, or negate the record.
Ted Langley for the record. If I'm not mistaken, there was a statement in the record that said they couldn't find proof of intentional dishonesty, but there was still some elements of dishonesty in the investigation. And I feel like through the discussion that we've had as a committee already, that there's enough evidence to modify the record to show that there was dishonesty involved.
Brian Siffin for the record, I'll second.
Member Frost, do you have anything to add?
I apologize for coming back late. I just wanted it known that I work at Snake River with Officer Gutierrez. He did reach out to me about his mitigating letter. I gave him some advice, basically, and then he wrote it without any input from me. I've also repped him on a couple of things that are going forward right at the moment with Snake River also, just so we're clear where I'm at with him, so.
Nick, kind of for the record, I would ask for, that was going to be my question. Is that something that I do, or is he basically offering to recuse himself?
You can inquire, or I'm gonna give an explanation. With an explanation? Okay. So, hello, Member Frost, this is Marie Atwood for the record. I wanted to make sure for our record-keeping purposes, it sounds like you've had some specific one-on-one conversations with Mr. Gutierrez regarding the case, and perhaps were consulted almost for advice or assistance on his preparation of what to submit to the committee. Under those circumstances, I think it's appropriate that we inquire if you would be okay recusing yourself from the deliberations on this one, just so that we can avoid even a perceived conflict of interest. Not that the committee members and the agency don't trust your judgment, but I feel that would be appropriate.
No, and that's why I brought it forward. I wasn't quite sure, and after I had talked to him, I realized what he was talking about, and I was like, oh, yeah, no, that wasn't good. So, yeah, I just wanted it out there. If I need to excuse myself, I will.
Okay, we really appreciate you coming forward with that information.
Nick Hunter for the record. Yeah, I would make the recommendation to you, sir, that you recuse yourself from this record and this deliberation.
Noted.
Okay. Following that, we are back to a motion to either affirm, modify, or negate the record. I believe we received a motion from Captain Langley to modify the record to include the moral fitness violation of dishonesty and otherwise accept the record as prepared. And we have a second. I'm just getting myself caught up.
All right, we are voting on a motion to modify the moral fitness violations as presented to include dishonesty. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Fresco?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committeemember Stefan.
Aye.
Motion passed.
Thank you. Okay, I will now entertain a motion about whether the committee wants to take action or not on this case. Please remember to state your name for the record and your reasoning for either. Nick Hunter, for the record, I make a motion that the committee take action on this case based on the identified aggravating factors, especially to include the one including the finding of dishonesty by the committee discussion.
Lori Frasco, I would second.
All right, we are voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committeemember Aldrich?
Aye.
Committeemember Bowden?
Aye.
Committeemember Frasco?
Aye.
Committeemember Hartford?
Aye.
Committeemember Langley?
Aye.
Committeemember Mays?
Aye.
And Committeemember Stefan.
Aye.
Motion passed.
Thank you. With the motion to take action, we'll now move on to, I'll entertain a motion regarding the potential period of ineligibility. Since this case now does include dishonesty, potential period of ineligibility would be 3 years to a lifetime.
Josh Aldrich for the record. Question for staff. Could we clarify when that would potentially begin? Please. Thank you.
Melissa Langbacher for the record, because the charge occurred while Mr. Gutierrez was employed in public safety and he is currently employed in public safety, any ineligibility date would be based on the date of the board's review and approval, so a future date probably in January of 2026. Sorry, my brain shorted out for a minute there.
Thank you.
Mara Bowden for the record. So just for clarification, he's currently working, but he would become ineligible as of January?
Yes, so it would be based on the date of the board's approval. So DPSST, after the committee makes a recommendation, would send him a notice that we're seeking to take action. He would still have the ability to contest that, which may change that date of a final order, but if no hearing is requested and the board approves, it would become a final order on that date, which would be the start of the ineligibility.
Thank you for that clarification.
Nick Hunter for the record. I would make a motion that we recommend an ineligibility period of a lifetime of ineligibility based on the dishonesty that is apparent in this case from Mr. Gutierrez regarding the stories that he told once confronted about this, when it started with what potentially in his mind was a more humane act of just letting the horse go as opposed to euthanizing it, but then his continued dishonesty when confronted with that is of great concern and would lead to my motion for an ineligibility period of a lifetime.
Josh Aldrich for the record. I'd second that motion and also add reference to the steps that were taken in regard to the post to actually kind of hide some of the factors that could have potentially led to his ultimate prosecution.
All right, we are voting on a motion for a lifetime ineligibility period. Chair Hunter,
Aye.
Vice Chair Cameron,
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bowden,
Aye.
Committee Member Fresco,
Aye.
Committee Member Hartford.
Aye.
Committee Member Langley,
Aye.
Committee Member Mays,
Aye.
and Committee Member Stefan.
Aye.
Motion passed.
The next case we'll move on to is Michelle Hubbard. And Michelle Hubbard is presented by Melissa.
Thank you.
Thank you.
Melissa Lancaster for the record. The department opened a professional standards case to review Michelle Hubbard's separation from the Department of Corrections. Her separation was part of a settlement agreement which followed an investigation that found that she had failed to maintain appropriate boundaries with an adult in custody after she was observed supplying access to contraband items to an adult in custody. In a review of the information provided, the department found misuse of authority, that Hubbard intentionally used her position to obtain a benefit, and misconduct, that she failed to maintain appropriate boundaries with an adult in custody, provided that adult in custody with access to contraband items, some of which could potentially be used to aid in an escape from custody. Hubbard's failure to follow security protocols when she provided access to the contraband items threatened the efficient operations of the Department of Corrections. When Hubbard failed to follow security protocols and maintain appropriate boundaries with the adult in custody, it also harmed the adults in custody when they were placed in disciplinary segregation. Mr. Chair.
Thank you, Melissa. First, I'll ask for consensus of the record and to adopt this record for further discussion. Okay. With consensus, we will move on to a discussion of aggravating and mitigating factors. Please remember to state your name and identify whether you are presenting an aggravating or a mitigating factor for the record.
Brian Steffen for the record, aggravating factor, it's stated on the report she had previously been a subject of 6 investigations for other boundary-related issues. Aggravating factor that her labor representative, who had defended her multiple times, was the one who brought this interaction to management's attention.
Ed Langley for the record, kind of on the follow up the 6 previous investigations. I guess I just want to I wanted to point out that it just leads to the obviousness that this one wasn't an isolated incident. And I also found it aggravating that in providing contraband to an inmate that could potentially lead to an escape, not only does it put members of the facility at risk, but also local law enforcement if they had to respond to an escape, and the general public. So there's a lot more people at risk than just the people that work at the facility.
Nick Hunter, aggravating factor. This case involved what is going to be significant harm to the AIC. The AIC had been what would appear to be in the same facility for years, and granted it takes 2 to tango, but the actions of Ms. Hubbard led to this AIC being moved. And when this AIC was moved in facilities, he did suffer harm, whether that's a direct correlation or anything, I can't speak to that, but the AIC was harmed by being moved. Second aggravating factor is, I'm not exactly sure how to word this one, but there wasn't apparently any apparent dishonesty, but there was no real accountability for actions. She was fairly blasé in all the interviews, like, I did that. A little bit of deflecting where It wasn't that she, her answer was, I haven't directly been told that I can't do that, or putting it off on the kitchen or commissary manager there, where I've been told I can do this, but not really taking any account for her own actions.
Josh Aldrich for the record. I believe an aggravating factor, although I will say I would defer to our partners here from the Department of Corrections because I'm not familiar with this form number. I saw a reference in the report that not only were contraband items potentially shared with this AIC, but there was also information on a Measure 17 form that it says contain information about other AICs. And this information was shared with an AIC who should not have had access, which I believe also aggravates things because it potentially just shared personal information and put others at risk once again.
Brian Steffen for the record, continuing with that, the Measure 17 form is what, for lack of better words, is the pay for the AICs that are doing work. So one AIC in this case had access to adjust the pay for the other AICs.
Nick Hunter, aggravating factor. She was in fact having this AIC do work for her.
Brian Steffen, aggravating factor, a little bit of clarification of the prior boundary investigations. 2 of the prior investigations had been with the same AIC, and she had not made any adjustments.
Mike Mays for the record. Aggravating factors for misconduct. Officer Hubbard was shown to have brought a personal cell phone inside the facility and gave the AIC access to that cell phone to see photos of her.
Nick Hunter, aggravating factor on the same cell phone issue. There's the question around her work phone and her work phone. She was very ambiguous about whether it was left in her bag or not, but left in the side compartment of her bag, which that AIC moved, which would have then given that AIC direct access to that work cell phone. So I believe the aggravating factor is in just property control and property management of what would otherwise be contraband.
Brian Steffen for the record with a question. There are a lot of, the AIC's name is redacted. I did see it at one point in here. Does it say what his sentence was? Is that something that can be part of the aggravating? I don't know if it's in the record that we accepted or not, so I don't know if I can talk about it.
I don't, Nick Hunter for the record, I don't remember ever, the only thing I remember specifically about the AIC's sentence, so to speak, was just how long he had been there, but I don't remember any clarifications about what he was in fact sentenced for.
Or how long.
Or exactly how long he would ultimately be there.
Hey, John Frost for the record, to clarify, according to the report, that is a personal cell phone, not a work cell phone. Also in this report, she talks about her sharing her personal pictures of her son's diamond art project that she was working on.
Mike Hartford, for the record, just a clarification, there was no finding of a PREA violation in the DOC's investigation report, is that correct? I didn't see a violation of PREA in there. It's just interesting to me, the intensity of their relationship where he would have punched somebody in the face if they touched her bags. He's helping her with her medication to control some symptoms she may have. Like, they were very close, and I was just curious about PREA violations that I did not see in the record.
Nick Hunter, for the record, I did not see anything related to PREA as well. Any other aggravating or mitigating factors?
Lori Frasco, for the record, I would say an aggravating factor is that Ms. Hubbard had been employed for 27 years with the department and has had multiple hours of training that discusses boundaries, code of conduct, code of ethics. And she still allowed her boundaries with AICs to become blurred, per se, and put that entire facility in the department at risk.
Melissa, would you like to read back those factors you do have?
Yes. Melissa Lane Botcher, for the record. I don't see any mitigating factors that were identified, but for aggravating, I have that Hubbard was previously the subject of 6 investigations for boundary issues. The union representative who previously represented her in some of those investigations reported her conduct. It wasn't an isolated incident. She put members of the facility, local law enforcement, and the general public at risk due to, after she gave access to an AIC access to methods of escape. Actions by Hubbard led to an adult in custody being harmed after they were moved to another facility because the move was related specifically to Hubbard's actions. Although there was no apparent dishonesty, Hubbard was very blasé and deflected her responsibilities and actions in the case. Contraband items were provided and information was provided about adults in custody to an AIC. One adult in custody had access to adjust the pay for multiple AICs. She had an adult in custody do work for her. 2 of the prior investigations were related to her conduct with the same adult in custody, and she failed to adjust her conduct. She brought in her personal cell phone into the institution and gave access to it to an adult in custody. She gave an ambiguous answer about a phone that was in her possession and backpack when an adult in custody moved her bag, and then failed to restrict access to those items. And then it was clarified that it was her personal cell phone that was in the bag that the adult in custody moved. And then lastly, she had, it was aggravating that she had 27 years of experience with multiple hours of training and still allowed boundaries to be blurred and put others at risk by her actions. Mr. Chair.
Thank you, Melissa. Is there a consensus of all of the aggravating? There were no mitigating factors just presented. Okay. With the consensus, I'll entertain a motion to either affirm accepting it as it is, or modify or negate based on the moral fitness violations and the report as completed by staff.
Brian Steffen, for the record, I move that we recommend to take action based on moral fitness and all of the aggravating factors that I'm not gonna list.
Taking action, it's Nick, for the record, taking action is the next question.
Oh,
This
sorry.
is
Affirming.
this is where,
Affirming, yes, I move that we affirm based on the aggravating factors.
Barba, next.
My turn to get ahead.
okay, so I have a motion to affirm, and I think there was a.
I did.
Yep, there was my second. Okay.
We are voting on a motion to affirm the moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
Thank you. Now, I will entertain a motion to either take action or take no action from the committee. Please remember to state your name for the record and your reasoning for taking action or making this a recommendation of no action.
Brian Steffen, for the record, I move that we recommend to take action based on all the aggravating factors.
I'll second Jennifer Cameron, I'll second.
Voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
With a motion to take action, the next thing we will move on to is I'll entertain a motion regarding the potential ineligibility period for Ms. Hubbard. Ineligibility, there is no dishonesty that was found, so misuse of authority and misconduct are ineligibility period of 3 to 10 years. Please remember to state your name for the record and your reasoning for your ineligibility period recommendation.
Brian Steffen, for the record, I move that we recommend 10 years based on the multitude of aggravating factors and the facts of the case.
Jennifer Cameron, I'll second for those reasons. I wish in this case we could recommend lifetime. But 10 years is what I also.
Motion in a second.
We are voting on a motion for a 10-year ineligibility period. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
Committee Member Steffen?
Aye.
Motion passed.
All right, we'll move on to our final case, August Lothian. And August Lothian will be presented by Melissa.
Thank you. Melissa Lancaster for the record. The department opened a professional standards case to review August Lothian's resignation from the Washington County Sheriff's Office during an investigation into allegations that he was untruthful during his background investigation. The Washington County Sheriff's Office sustained preliminary findings that Lothian was untruthful after he failed to disclose in his background process that he was the subject of a military protection order and provided inconsistent answers to questions that he gave in other background questioning.
For further discussion. With the consensus to adopt, I'll open up the case for discussion. Discussion of mitigating or aggravating factors. Please remember to state your name for the record and identifying either aggravating or mitigating.
Brian Steffen, for the record, I'll give him mitigating that he claimed he had given his 2 weeks notice and they stopped assigning him. So he claim that he didn't realize or think about it as being fired, that he didn't report, or will give aggravating, that even if that's arguable, or multiple instances of dishonesty and deceptive behavior indicating overall aptitude to untruthfulness.
Melissa Langbacher for the record. Could you just, I think I got confused and halfway through that. Was it mitigating that he, that it was mitigating that he claimed, that he gave his 2-week notice and didn't think it was something that he needed to report? And then what was the second part?
Brian Steffen for the record, for the mitigating, he gave us 2 weeks and they stopped assigning him. They said he was fired and he didn't report that as being fired.
Okay.
So I could understand, potentially. The aggravating being that even if that one's arguable in my mind, there are multiple instances of dishonesty and deceptive behavior indicating the overall aptitude toward untruthfulness.
The kind of aggravating factor, he, when confronted with this information by Washington County, he chose to resign and not participate in the internal investigation process. Knowing the accusations against him, his choice to not participate, in my mind, demonstrates an admission of guilt. Or at least a no contest plea, I guess, if we want to use a correct court term.
Marta Wood for the record, aggravating factors. They not only lied about that, but also about drug use, not being truthful on the exact amount of what it exactly was and how many years he actually engaged. And also aggravating is not only was he a part of a protection order, but he was part of a protection order for sexual misconduct.
Josh Aldridge for the record, adding to that, and also I think making it as more of an aggravating factor is that it seems the places where he was deceptive are those places where it's pretty clear that it could affect your possibility for employment in law enforcement. They surrounded some pretty significant accusations of things that had happened in his past.
Brian Steffen for the record, appears to me as being confusing on purpose to be deceptive and is continuing to attempt to be hired at multiple law enforcement agencies.
Any other aggravating or mitigating factors to be entered into the record? I saw Member Frost light came on real quick. Member Frost, did you have something to add?
No, I didn't. Sorry. I don't know what happened there.
All right, Melissa, if you could read back what we have.
For mitigating, his employment separation, where he claimed that he gave 2 weeks notice and then stopped getting assigned, but in reality was actually fired, was an understandable reason to think that maybe he didn't need to report that separation as a termination. He also gave multiple instances of deceptive behaviors and had an aptitude for deceptive actions. He chose to resign and not participate in the investigation, which demonstrates an admission of or no contest recognition of his guilt. He lied about drug use and was not truthful on the length or the number of times that he used drugs. He failed to report a military protection order for sexual misconduct. The places in the background investigation where he was dishonest were areas that could impact his employment. He attempted to be confusing and applied at multiple agencies. Mr. Chair.
Thank you, Melissa. Consensus regarding the aggravating and mitigating factors presented?
Martin, for the record, I'd just like to actually fix that. It was actually sexual assault, not misconduct.
Thank you.
And that was my bad. That was my word used. But written it says assault.
Okay, with the aggravating and mitigating factors, I'll open the discussion now regarding the moral fitness violation of dishonesty. I'll entertain a motion to affirm, modify, or negate the record.
Mike Hartford, for the record, I move to affirm the findings or recommendation of dishonesty based on the multiple counts in the record.
Martin, for the record, I'll second.
All right, voting on a motion to affirm the moral fitness violations as presented. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
All right, with the acceptance of the report, I'll entertain a motion for the committee to either take action or not take action in this case. Please remember to state your name for the record and your reasoning for your recommendation.
Brian Steffen, for the record, I move that we recommend to take action based on the cases presented and aggravating factors.
Nick Hunter, I'll second that.
Voting on a motion to take action. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Flasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Steffen?
Aye.
Motion passed.
And with a recommendation to take action, we'll move on to a potential ineligibility period. This does involve dishonesty, so the potential ineligibility period would be from 3 years to a lifetime of ineligibility. Kind of for the record, I'm going to ask a question real quick. Can there be clarification? So why is this coming to us? Because he's not applying for another job in public safety, as I understand it. He's applying for something else.
He currently has a certification in basic corrections, so we're reviewing his separation from employment,
Okay.
in which he was found to be dishonest when applying to another agency. So it's a little bit confusing on how it ended up with us.
Sort of post hoc, but now that's what we're looking at.
Yeah.
Okay. So I will entertain a motion concerning a potential ineligibility period.
Ted Langley, for the record, I'd recommend a lifetime ineligibility period, mostly based on the fact that his dishonesty with the two agencies occurred at like one of the very first steps that you take in getting hired. And I just don't really see any necessity to offer him an entire career to continue being dishonest.
Jennifer Cameron, I'll second that. I want to note too that in his letter of explanation, he says, I have always tried to be honest. Honesty isn't something you try to do, so you either are or you aren't. So I second Captain Langley's motion.
Right, we are voting on a motion for a lifetime ineligibility period. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasca?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Seven.
Aye.
Motion passed.
Thank you. That concludes action for that, and we are moving on to agency updates. Oh, I'm sorry, we moved on to an administrative revision request, which specifically involves Chris, and I shouldn't have put a check mark there.
No.
I'll
Lots
go
of
back and
discussion
the
to
floor is
have.
yours, sir.
It is kind of an agency update though, if you want that covered. Chris Enquist for the record. Happy to see everybody this morning and online. So I have an administrative revision request for you regarding the parole probation training program. And there's kind of two pieces to this request. One is the actual ask, but the larger one is just to kind of forecast potential larger changes to that program on the horizon. But we're going to start with an administrative revision request. And so just to kind of make sure everybody's on the same page, because I know some people are new to role. Generally, most recently you saw the basic parole probation curriculum request come through. That was a full and formal revision process involving a public work group, a lot of work, a lot of time. When we look at what the board oversees for curriculum, we define that kind of as goals, outcomes, and hours. So goals are kind of the general instructional focuses of the course. Outcomes are the instructional pieces students are expected to retain post-course, right? Like the pieces they need to know. And hours of instruction allotted to each session or each training topic. When we're touching all three of those for revision, that's generally the trigger point for a kind of a full work group revision, right? The whole program's changing. The reason this is coming to you as an administrative request is because we're really talking about reorganizing hours, those topics within two programs, and considering consolidation. Both those programs are pretty recently revised. The memo kind of speaks to that. Parole probation you just saw. The ARM program is a little stale, but not too much, right? It was approved in 2021. So our feeling at this point is generally the goals and outcomes for both those programs are set. It's really talking about what can we do with the hours if we were to consolidate those programs to kind of spread that learning over what would likely be a 7-week run for parole probation. The memo speaks to the history on it. I'm not going to go into that in too much detail, but the general why behind the revision. Running a condensed skills program has a lot of just necessary evils that come with it, right? Slamming, that much instruction related to deadly force into a 1-week historical model or even a 2-week, the current model. That's a lot of learning for students to pick up in a short period of time, especially when you consider they have to do it in kind of isolation from the rest of the skills they get in basic. That 5-week plus 2-week model has consequences. While it's a good program, we're seeing poorer returns out of it than we have previously, both in terms of student success within the program and our own staff's kind of satisfaction with what they're getting out of students during the course of instruction. The other piece that's tripping this is the need for that program is starting to become a little bit of a redundancy. If we roll back the clock 10 years when we had, at that point, 2 agencies operating in an unarmed capacity within parole and probation, one of them representing a pretty good body in terms of the numbers. It made sense to kind of accept that trade-off of a bifurcated training model. The larger of those 2 unarmed agencies is in the process of transitioning to an armed model. The other agency doesn't have much heartburn over the notion of their staff being trained in firearms to potentially convert to an armed model down the road. Those things kind of add up to us as like, we're at a really good point to consider, should this program be looked at for consolidation? So the administrative proposal you have is really just giving us the green light to proceed on that project, but doing it with something less than the traditional full public work group. It would likely consist largely of DPSST staff sitting down, retemplating those programs, and then we would do some engagement with certain constituents, agencies that offer loan instructors here quite a bit to give us input on that, and then we'd circle back through OACCD for kind of their input on the suitability of that program. This would all likely be targeting the next board cycle for some kind of initial feedback to CPC. And depending on how successful the project is, if we go forward with it, that could be an approval point, or that could be an advisement to CPC of like, yep, we have a possible product in the works, and we're thinking we pilot it much further down the line, or 2 or 3 months down the line, and CPC would be either approving the actual change or some kind of pilot. I think that sums it up pretty well. The only piece that's a little loose there is process, and a lot of that's just going to come down to staff's capacity to get this done, and kind of layering the board timelines against our timelines for when we'll offer programs. That'll probably be the real trip point. What questions do you have?
So I think it's a little interesting that we're almost doing this on the community corrections side, yet we're having a different conversation on the basic corrections side, and that conversation is yet to come to fruition. And I haven't anticipated and know where that goes, that we're not going to end up making significant changes to basic corrections. I will tell you, I support this in the nature of there's no way you're going to achieve effective interleaving in 2 weeks. And so that 2-week course is, for lack of a better term, check the box, because there's very little transference of skill outside, which I think you all have recognized, and we're seeing the results of that. So the long way around, I'm supportive on the training side of it, that if we're gonna arrive at firearms anyway, then we would be better off combining it, taking that time and interleaving that firearms throughout that 7 weeks, achieving a better sort of learning, retention, transference model for that skill, knowing how important that skill is if that person needs to call upon that skill in the field.
Yeah, I appreciate that. I think, I haven't spoke a lot to the operational impacts, because in many ways, what you order, we will do. But yeah, running as a standalone program, it certainly creates a lot of obstructions to effective learning, like interleaving. It also is just a really challenging schedule for us to operate. Condensing that many firearm sessions in a 2-week block really creates a lot of venue conflicts for us to operate. So it's a really nice example of potentially kind of a plus, right? We could see an enhancement to student learning and also arrive at an academy template that's a lot easier for us to operate with confidence.
Mike Hartford, for the record, I would second that and say that one of the issues over the last, I'd say, 10 years is the ability or the consistency that the academies had to even have those 2 classes back to back for the folks that do attend the armed portion. Having them separated by several weeks becomes problematic operationally, probably for the academy or here, as well as the agencies that are sending their folks there. So I'm supportive of the combination for the training components, the operational pieces, and I just appreciate that you and your staff are considering that moving forward.
I think
Jennifer, go ahead.
Jennifer.
Jennifer, honestly, I'm a parole officer too, and I'm gonna date myself, but I was around when we first started getting firearms. I actually went to other training, became a deputy reserve, just so I could get additional training because that was important, so I'm happy to hear that anything to advance firearms training for PNP is a wonderful thing, so.
I'll take it, thank you. I think the only real action item I have is just that confirmation from CPC, or the opposite, that will proceed with an administrative revision that will generally preserve outcomes and goals within the program, but would have the latitude to redistribute hours as appropriate, and we'd report back to you for final approval on that.
And just for the record, Chris, you were engaging, sorry, Nick, for the record, you were engaging with OACCD and working at least through that with OACCD, which would give you sort of impacts across the state.
Yeah, we would likely agenda to OACCD prior to coming back to CPC for kind of their formal input on it. But we've engaged with local agencies quite a bit, particularly the ones that are likely to be the most heavily impacted by a change.
No, and I think Commander Hartford brings up a great point, and if you're on the eastern side of the state and you've got to send your folks for 5 weeks and then you got to figure out how to send them for another 2 weeks, operationally that's a big challenge. And so just knowing that they're gone for 7 weeks, not to mention the increase we're going to get in training, I think there's huge positivity to that.
So we need to make a motion. So Jennifer Cameron, I'll make a motion to to accept? What am I? I know, I'm like
To
going blank
support,
right
to
now.
approve.
Agree with?
Yeah, I didn't know the.
To approve the revision request.
Yes, there we go, to approve the revision request.
As presented.
As presented.
We're voting for the record in a second.
Alrighty, we are voting on a motion to approve the administrative revision request to the parole and probation training programs. Chair Hunter?
Aye.
Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bowden?
Aye.
Committee Member Plasko?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Seven.
Aye.
Motion passed.
Thank you.
Wow, I'll stumble through this.
Agency updates, Deputy Director.
Yes, on behalf of the director, since he is on a much deserved vacation. You know, I wanna take a moment, Ted, this is the one time you're not in person. I would say 99% of the time you are in person. And the day that we wanna say our thank yous for 4 years of dedicated service and commitment, and to present to you, as you can see virtually here, you know, our appreciation. Just want to take a moment to say you've been invaluable to CPC. In the 2 years that I've been around, you were thoroughly engaged, thoughtful in your comments and contributions, and just want to say thank you very much for your dedication to DPSSD and to your profession. Really appreciate it. And Juan will send it out.
I can take it to.
Well, it's been an honor to do this. I've really enjoyed it, and I've enjoyed getting to actually know a few people a lot better. So thank you very much.
And probably only,
I'll bring it to you.
there you go.
I'll have the sheriff give it to you.
I like it. The others is if most of you and those who are also on state budget is just, we did submit our reduction packages as asked for 2.5 and 5%. And they were approved to submit, that's as far as I'll say, you know, we just approved to submit, we met the requirements. But should they take portions or all of it, it would come down to class sizes, classes, including the leadership track that we offer up. We get into the 5%, then we're talking personnel. So we're following this very closely. Our saving grace, hopefully, is that we're not primarily general fund. We are CFA, and we'll see the mid-November forecast to see how the CFA's criminal fines account is doing. It was trending a little bit upwards, so as long as it continues up or sideways, that will help us. But we're just standing by. I think next week is when PubSub goes. There's larger agencies that have been asked to present their reductions and their concepts. We have not, so they have our information. We're just standing by, but certainly if it looks like we're gonna be impacted and we think that it will impact the constituents, we'll be sharing that with you in another meeting. Go ahead, Marie.
Thank you. Marie Atwood for the record. I would first like to say on behalf of Professional Standards, thank you to everyone for your participation today. I am always impressed by the level of engagement and really fruitful, important discussion that I hear out of this group. The work you do is so critical to making sure that this field, our industry, maintains in the way that we want it to. I would also like to thank my staff, our team, Juan, for all of your tireless work in getting this meeting ready, as you always do. With that said, my only updates are, you know, a couple of things that might involve a little more work for everybody. So the first case that we tried to hear today, the one where Mr. Bond came and provided his mitigation. So just to address what we've been having some sidebar discussions about how to move forward with that. The reason why it was tossed onto the agenda later than normal is because there's a little bit of an emergent status with his joining the academy in January. However, generally speaking, we try not to have somebody already in the academy when their case is heard by a policy committee or the board. So to that end, because we got partway through his process today, so that we can avoid a possible situation where he might be pulled from academy based on the committee's decision, or just where his future is kind of up in the air, especially because if he ends up going before the board, it could be up to 6 months from now before his case is actually resolved. Our plan, if we can achieve a quorum, is to try to toss together an emergency meeting that's just going to be for that case deliberations only. Virtual attendance is obviously going to be fine, but we're going to try to get that scheduled sometime between now and his date to begin academy in January. And hopefully that way his case could also go to the board in January if needed. So just a heads up on that. You'll probably be receiving emails from Juan shortly about trying to schedule something that's workable for a quorum of people. The other only real agency update I have on the professional standards side of thing is that at the end of October, our moral fitness work group convened for what, about 4-hour meeting? 3 hours? 4 hours? 3. Yeah. And that committee has obviously been doing a ton of work over a really lengthy span of time to get our administrative rules for moral fitness guidelines up to speed, clarified, more robust, adding some things that haven't been there, moving some things around just so that they're easier to use and for our both the public and our committee and board members to grapple with. So if all goes according to plan between now and the end of the year, there should be a level of DOJ review on our proposed rule changes. And then if that is achieved in a timely fashion, it could be back on your radar as soon as the February meeting. So keep an eye out for agenda items and materials pertinent to moral fitness work group review. Otherwise, I think that's all I have for today.
I may add one more.
Yes.
On that emergency meeting, Captain Calpine for the record, just again, put it in time frame. The board meets in January, he starts in January. We'll want to get the material, your vote, onto the board's record for consideration. And when do they usually do, December?
December 18th.
So count on the meeting being before December 18th, just so we can make it meaningful and get it onto the board's calendar as well for their material. And that would give both the agency, the employee, and the board time to do all the considerations without impacting anything.
And I have a quick question. When you send the email, will you be including the staff report and all the information in that? Since the link to the information from today, I think it's usually gone, so.
Yes.
That was a double check, but resend it just so we make sure everybody has it. Thank you, Juan.
Well done, Chair. Thank you.
All right, so last but not least, thanks for bearing with me today as we tried to get through this whole thing. I feel for Jennifer right now and her having to do this. It's very interesting when you're trying to participate in the conversation, but you're also trying to facilitate the conversation. So I appreciate everybody doing that. I want to echo a couple of things that Marie said. This is extremely important. These are these folks' lives. These are these folks' livelihoods. So these are important decisions that we're being asked to make, or recommendations that we're being asked to make. So I'm a big one on participation. I appreciate it. I think everybody participated today in some way, shape, or form. And that's really all I would ask of as being your chair now, is just preparing for the meeting, coming to the meeting prepared, and then don't be afraid to say something. I think that's what makes for good, colorful, fruitful discussion, is to hear those differences of opinions and to hear what people truly think. So that's what this environment should be for, and I appreciate everybody kind of being committed to doing that together. So with that, I don't see exactly when the next meeting is, but it's going to end up being virtual. So some of us, or most of us, will see each other very soon. And with that, I will stop and enjoy your day. And we are adjourned.